A very warm welcome to all of you to our superb series going on various topics. We are doing this series on polity topics, and we'll be including some further topics as well. Okay, so this time let us dive into the central judiciary part. Correct. So let us look how the judiciary works. What is the judiciary? And we'll have some good important questions to be practiced in the same video. Uh, so let us go ahead. Okay. Uh, First of all, seeing the pyramid of this judiciary, the top we have the Supreme Court. That is the highest court of appeal, final interpreter of the Constitution. It is known as the final interpreter of the Constitution. Okay. The Supreme Court on the top. Now, what is the historical anchor for this? It is the Government of India Act 1935. Okay. Then we have the state level uh, court, apex court is high courts, correct? 25 of them are there. This is the second, first. Then we have the second, correct? Then we have the subordinate courts. That is the district and lower courts. Okay. So unlike the US system, this single structure enforces both central and state laws. So state high court can enforce central laws. Okay. Very important topic. I hope I have all your attention here. Okay. Uh, Series is getting a good response, so let us participate well. We'll go to the next one. Coming to Supreme Court. Now, how many judges are there? So always remember there are total 34 judges. That is 33 plus 1. Now, who is this plus 1? This is the Chief Justice of India. Okay. Chief Justice of India plus 33 judges. What is the appointment? How is the appointment? So there is a collegium. So the president consults the senior most Supreme Court judge. Correct. For Chief Justice of India appointment, it is the single senior most Supreme Court judge who becomes the CGI. Correct. So it was in second judge's case in 1993. Seniority dictates appointment for CJI. Okay, I have brought some extra brownie points also. If you remember this, well and good. You'll score very good in exam. So in which case? So it is in the second judge's case. Okay. Then we have how other Supreme Court judges are elected. So President, along with CJI, Chief Justice of India, and the Collegium. So what is a Collegium here? Four senior most Supreme Court judges. Four senior most along with CJI. Correct? The third judge's case mandates the collegium. Advice without it is not binding on the president. Okay, so it is not binding. CGI along with four senior most judges. Now, what are the qualifications to be a Supreme Court judge? First, it is they have to be a citizen of India. Second, they have should have been a High Court judge for 5 years or High Court advocate for 10 years. Okay, then or distinguished jurist in president's opinion. This is and please remember this both they have to fulfill, and this is or. Okay, either this or this. So please remember there is no minimum age. No minimum age. Maximum age is there, but no minimum age is there. Please keep this in mind. Okay, well and good. Let us go ahead. How a judge is removed, correct? So again, the process of impeachment. Initiation. First, there will be an initiation. The motion has to be signed by 100 Lok Sabha or 50 Rajya Sabha members. 100 Lok Sabha or 50 Rajya Sabha members. Then that initiation will come into action. Admittance. Speaker accepts or rejects the motion. Once they have signed and they have forwarded to the speaker will either accept or reject it. Correct? If the speaker accepts, the committee will probe. Correct? A three-member tribunal formed. CJI or Supreme Court judge plus High Court Chief Justice and distinguished judges. This is the three-member uh, committee which will be formed. Then, if they approve that yes, the charges are valid, special majority is needed, correct? That is, if guilty of proved misbehavior or incapacity, two conditions, both houses must pass by special majority, that is 50% of total membership and two-third present and voting. 50% of membership total has to vote and two-third of present and voting. So please remember, okay, 50% of total plus two-third P and V present and voting. Correct? If then still passed, President shall put an order and final seal of removal will say. So the Supreme Court or High Court judge will be impeached. Okay? Till date, no judge of the Indian Supreme Court or High Court have ever been successfully impeached. It is such a tough procedure. So there has been no impeachments, no Supreme Court or High Court, anyone, there is no impeachment. Okay, so going ahead, we have Supreme Court jurisdiction. We are seeing the Central Judiciary. So first we'll see about Supreme Court. They have some original jurisdiction in which, so first is the original jurisdiction. They have exclusive jurisdiction over federal disputes. Now, what are federal disputes? It is like center versus states, state versus state, a group of state versus center. Correct? All these issues will come under the jurisdiction of Supreme Court. This is the original jurisdiction. High Court cannot legislate on this. Writ, enforcements of fundamental rights. Writs. Correct? Third, appellate jurisdiction. Appellate in constitutional, civil, criminal matters, and special leave to appeal. Appellate means the top jurisdiction, correct? Then there is some court of record. What is this? Judgments as legal precedents, they will be recorded and they will be used for future judgments, correct? Judicial review, examining constitutionality of legislative and executive acts. Fifth and sixth, they have advisory jurisdiction. Article 143 as presidential consultation. Correct? So the president can ask for an advice from Supreme Court. Okay. Uh, Advisory pathways. President asks a question that, okay, please give me a advice on this. If it is on a pre-constitution treaty or dispute, pre-constitution, before the constitution came, treaty dispute, the Supreme Court has to give an advice. They are bound to give an advice. But if it is a question of public importance, SC may advise or may not advise. It is Supreme Court's choice. Okay. Opinion is advisory only, not binding on the president, not binding. Please remember, be it any advice, either pre-constitution or question of public importance. Okay. Going ahead, we saw about the Supreme Court. Now let us talk about the High Court. Okay. High Court composition. Strength is determined dynamically by the president based on the workload. Like in Supreme Court, we had 33 plus 1. There is nothing such case in High Court. Okay. What is the territorial architecture? Co-terminus with state boundaries. So if it is Allahabad High Court, it is automatically its territory will be in Uttar Pradesh. Okay. Seventh Amendment, 1956, says Parliament can establish a common high court for multiple states. J&K and Ladakh, Bombay High Court covering Maharashtra, Goa, Daman and Diu. So West Bengal High Court covers Andaman Nicobar also. Okay. So Seventh Amendment gave some exemptions that the particular state high court can have jurisdiction beyond state as well. Okay, so you can find examples here, correct? J&K and Ladakh. Bombay High Court is also covering Goa and Daman. Okay, now how the appointment algorithm works? Here we have High Court Chief Justice, correct? How? So, President, along with the advice of Governor, appoints the CJI. CJI, President, Governor, and CAJI. These combined go for the selection of uh, High Court Chief Justice. They together select the High Court Chief Justice. CJI is Chief Justice of India, please remember. So, President, Governor, and CJI go for High Court Chief Justice. Others, for other judges, it is President, Governor, High Court Chief Justice for other judges. Citizen of India, they have to be a citizen of India and held judicial office for 10 years, either some judicial office for 10 years or they have been High Court advocate for 10 years. Okay, just a moment. Yes, so just here we missed one point. Retirement is 65 years of age. Retirement for Supreme Court judges 65 and retirement for High Court judges 62. Retirement for High Court judges 62. 62. Okay, 65 for Supreme Court, 62 for High Court. Okay, so please remember for other judges, High Court Chief Justice comes in. For High Court Chief Justice, Chief Justice of India, Governor and President. Okay, next. High Court also has some judicial radar. What is that? Again, original jurisdiction in revenue matters, election disputes, higher value civil cases in four specific high courts. Then we have writs. This is concurrent with Supreme Court. Sorry, but broader in territory. Okay, so we have Supreme Court writ jurisdiction is narrower than High Court. That is the best part. Okay, Article 226. Then we have appellate jurisdiction, obviously. First or second appeals from district subordinate courts in civil and criminal matters. Don't worry, I'll be bringing a separate video for subordinate, that is the state judiciary also. Confirming death sentences. So any death sentence given in a district or sessions court will have to be confirmed by the High Court. Supervisory jurisdiction, administrative and judicial superintendence over all courts, tribunals in the territory, okay, except military, okay. Subordinate control, posting, promotion, and discipline of judicial officers, this is there, and court of record, as like just like Supreme Court. Supreme Court and High Court, they both have power to put contempt. Okay, they can punish in case of contempt, civil or criminal contempt. Yes. Okay, so this is about High Court. Uh, just a quick comparison for all of you. We have the territorial reach of Supreme Court as nationwide, but High Court is limited to the territory of that state or one or two exceptions. Correct? Composition 33 plus 1. Here the strength is determined by the president, not fixed. Okay, please remember this part. Appointment, president plus collegium of 4 Supreme Court judges. And here we have president plus governor plus CGI plus High Court Chief Justice. Okay, for High Court Chief Justice, these three will come into picture. Retirement age for Supreme Court 65, retirement for High Court 62 years. Supervisory, they have over all courts in India, and high courts have all court and tribunal within the state jurisdiction. Within a state, any tribunal except military will come into high court. Absolute ban in any court of India, that is the post-retirement practice for Supreme Court. Once you retire as a Supreme Court justice, you cannot practice. For a High Court, it is permitted only in the Supreme Court and other High Courts. So this is a quick comparison table for Supreme Court and High Court judges and selections. You can have a look. Quick recap I have given. Correct. So we can see Article 32 versus Article 226. We have the territorial. See, Article 32 is still narrower, correct? It is limited to fundamental rights only. Supreme Court can give writs with respect to fundamental rights only. High Court can give writs regarding fundamental rights plus ordinary legal rights. So you can see the circle of High Court, the diameter is bigger than Supreme Court. So please remember, High Court writ jurisdiction is greater than Supreme Court. Okay? Both courts can be approached directly for fundamental rights violations. Both courts. Paradox is Supreme Court is the ultimate guarantor, but the High Court writ jurisdiction is legally wider in scope because it encompasses legal rights as well, like property. Okay, so please remember High Court jurisdiction greater than Supreme Court in terms of writ. So Article 32 versus Article 226. Okay, now security of tenure. So the security of tenure, judges are removable only by severe parliamentary gauntlet. We have already seen the whole impeachment process protecting against executive whim. So it is not that if the Supreme Court retires, also the pension is guaranteed by the Consolidated Fund of India. Okay. Financial autonomy, salaries and expenses are charged on consolidated fund and non-votable. Please remember, High Court judge salary is also on consolidated fund. While High Court salaries come from the state, sorry, High Court judge salary comes from the state fund, but the pensions are charged on consolidated fund of India. So High Court judge salary is on state fund, state fund, but their pension is charged on consolidated fund of India for absolute post-retirement security that once they retire, even the state government cannot touch them. Correct? Fixed service conditions are there. They cannot be varied to a judge's disadvantage. And parliamentary bar, like conduct of judges in the discharge of duties, cannot be discussed in the parliament or state legislature. These are the four securities, major securities given to a Supreme Court or a High Court judge. Very, very important topic for the exam. Make sure you're following up with me. Okay. Now, what is contempt of court? Contempt of court is like a willful. So there are two kinds of contempt. Contempt means kind of disrespect, violation of respect. Now it is of two types. One is civil contempt, the other is criminal contempt. Correct? Civil contempt means willful disobedience to a judgment or order or willful breach of an undertaking. Suppose Supreme Court told that we are giving you order to vacate this land by so and so date, but you didn't vacate. So what you're doing, you are disobeying the Supreme Court order. That comes under civil contempt. Now, what is criminal contempt? Publication or acts. Definition like I am public, I am publicizing or I'm putting a publication which scandalizes or lowers the authority of the court. Suppose if I'm saying, just to quote as an example here, so that I don't get into criminal contempt, that Supreme Court is very bad, Supreme Court doesn't do anything, Supreme Court is waste. This is an example of scandalizing or lower the authority of the court. Prejudice or interfere within with the due course of judicial proceedings. So if some proceeding is going on and someone is trying to interfere forcibly, that is a criminal contempt and obstruct the administration of justice. So if someone is trying to influence the case or if someone tries to put in some criminal influence, that comes under criminal contempt. The SC can punish contempt of itself. Supreme Court will punish itself. High courts and tribunals nationwide. High courts can punish contempt of themselves and their subordinate courts. Supreme Court will punish for itself, High Court will punish for itself and for subordinate courts also. So both of them are having a court of record and they both have contempt of court powers. Please keep in mind. Okay. If we see, often this question comes India versus US comparison. So judicial structure, we have an integrated judiciary, integrated SC oversees central and state laws. They have a separate judiciary. They have double judicial system. It works double. Philosophy wise defends rights via procedure established by law. This is the theory which runs in India. This is the philosophical backbone of judicial thing, procedure established by law. Whereas in US, it is due process of law. Due process of law. Jurisdictional breadth, we have immense appellate scope, be it constitutional, civil, criminal, plus discretionary special leave to appeal any court, tribunal, advice. So you can see the powers of the Supreme Court here. Jurisdiction is very wide, but their original jurisdiction covers naval, maritime, but appellate is confined strictly to constitutional cases. In USA, the appellate jurisdiction is only for constitutional cases. No advisory jurisdiction there. We have advisory jurisdiction to the President of India. Correct? We have legislative control. Parliament can enlarge Supreme Court jurisdictional powers, whereas in USA, jurisdiction strictly limited to that conferred by the Constitution. So we can say that Indian Supreme Court wields a uniquely expansive blend of original, appellate, and advisory powers, acting as the ultimate guarantor of rights within a tight framework. So if we do India versus USA, obviously India is greater than USA. Correct? I hope the picture is pretty clear. We have seen the appointments, age, colleg collegium, impeachment, correct? Now, let us have some high 20 yield practice questions I have brought for you. Uh, Make sure you practice them. Questions are on the left, answers will be on the right. Make sure you don't look at the answer and do comment how many of the questions you got right out of 20. Okay, let us start. Under which article of the Constitution can the Supreme Court review its own judgment? Can review its own judgment under the article. So we have seen uh, court of record. So it can review its own judgment. This is under Article 137. Okay. Allows the SC to review any judgment pronounced it by it to rectify any error. Please remember Article 137. The special leave petition is a discretionary power of the Supreme Court under which article? The special leave petition is a discretionary power of the Supreme Court under which article? It is under Article 136. Okay? 136 grants the Supreme Court the sweeping discretionary power to grant special leave to appeal from any judgment. You can just pick it up as a special leave. Okay, both the Supreme Court and High Court under Article 129, you can have a look here. Under Article 129 and 215 are courts of record. Please remember they both are courts of record. Okay, their proceedings are kept as perpetual memory and they can be referred to later in future cases and they hold the inherent power to punish for contempt. Please remember this. Okay, third question. The power of Supreme Court to decide disputes between center and the states fall under its which jurisdiction? Please remember, please see the Supreme Court power to decide disputes between the center and the states. It falls under its original jurisdiction. Supreme Court can do that, High Court cannot do that. Under Article 131, federal dispute, center versus state, state versus state, go directly and exclusively to Supreme Court. Okay, please keep that in mind. Article 131. The advisory jurisdiction of the Supreme Court is mentioned in the advisory jurisdiction to the President of India is, we have just now talked about it, Article 143. The President can seek advice and there are two cases we saw in which one the Supreme Court has to advise, in which in one they can avoid. Okay. Next, which High Court has the largest jurisdiction in terms of number of states? Which High Court has the largest jurisdiction in terms of number of states. So it is the Guwahati High Court. Okay, it holds jurisdiction over a massive territorial span covering four states: Assam, Nagaland, Mizoram, and Arunachal Pradesh. Guwahati High Court. Okay, the spelling might change. Somewhere it is, some places it is Guwahati also. Okay, it is in Assam. Okay, which High Court has the highest number of benches? Which High Court has the highest number of benches? Again, Guwahati High Court. To efficiently manage a massive jurisdiction, we have seen over four states, including Assam. They have three distinct benches at Kohima, Aizawl, and Itanagar. Okay, so highest benches and highest jurisdiction has been given to Guwahati High Court. Next, the total number of high courts in India is currently is very easy question. Correct? 25. Okay, a quarter, 25th. And the newest edition of Indian jurisdiction is the Andhra Pradesh High Court situated in Amravati. Okay. Next, the common high court for two or more states can be established by who will establish a common high court between two or more states? Who will do that? The parliament will do that by the law. So, under Article 231, the Parliament wields the constitutional power to establish a common high court for two or more than two states. So, please remember it is not the Supreme Court, not the President. Okay, the Parliament will do that. Who has who was the first female judge of the Supreme Court of India? This is a PYQ. Who was the first Supreme Court female judge? It was Fatima Bibi. Fatima Bibi, Justice M. Fatima Bibi, made history when she was appointed as a Supreme Court judge in 1989. Okay, who is known as the guardian of the Indian Constitution? Guardian itself, you can make a guess as the Supreme Court, acts as the ultimate protector of the Indian Constitution and people's rights. Make sure you're remembering it. It is not the president. Please don't get confused with president. Okay. This concept of public interest litigation originated in which country? This PIL originated in which country? So it was USA. While originating in the US, PIL was heavily pioneered in India by visionary justice like P.N. Bhagwati to drastically expand justice in India. If Indian terms, you can say it is a new innovation, but it was already practiced in USA. Now, who was the person who introduced in India? Please remember this name, very important, Justice P.N. Bhagwati. Okay. Next, in which case did the Supreme Court propound the basic structure doctrine? In which case the Supreme Court propound the basic structure doctrine? So it is the most famous case, Keshav Nanda Bharti case. 13 judges bench, largest till now. 13 judge bench ruled that Parliament cannot alter or destroy the foundational basic structure of the Constitution. Basic structure of the Constitution. Please remember, we call it as KB case in short. Correct? Keshav Nanda Bharti case or KB case. Okay. Corrective power. Which article empowers the High Court to issue writs for the enforcement of fundamental rights? Which is that? Which is that? Article 226. For Supreme Court, it is Article 32, and for High Court, it is 226. Please remember, 226 is wider in jurisdiction compared to 32. Okay. Which writ is issued by a higher court to a lower court to quash its order? Which writ is issued by a higher court to a lower court to quash its order? Which writ is that? That is the certiorari. Okay, meaning to be certified. This writ is curative in nature and actively corrects jurisdictional errors of lower courts. Okay, high courts have wider jurisdiction than SC under Article 226. We have already seen, correct? Whereas Article 32 is just restricted to fundamental rights. Please remember this. Okay. We have next, what is the maximum age for a high court judge to hold office? What is the maximum age? Please remember it is 62 years. For Supreme Court, it is 65. Okay. Next, a High Court judge submits their resignation to whom? If I am a High Court judge, I'll resign to whom? Only to the person who has appointed me. Now, who has appointed the High Court judge? President of India. So, despite operating entirely at state level, High Court judges are appointed and they resign to the President of India. According to the Judges Inquiry Act 1968, a judge can only be removed for proven misbehavior or incapacity. Please remember this. Only two conditions, either proven misbehavior or incapacity. Via a motion we have already seen by special majority. Okay, no SC judge has been impeached so far. SC or High Court judge. The salary and allowance of Supreme Court judges are charged upon on whom it is charged consolidated fund, public account, contingency fund, or respective state fund. Obviously, consolidated fund of India. This mechanism ensures security to the judicial office. Next, what is the minimum number of judges required for a constitutional bench? For a constitutional bench, what is the minimum amount required? So it is 5. Okay, it is just the options are repeated here. It is 5. So Article 145, Clause 3 says that strictly mandates to at least 5 judges to decide substantial questions of constitutional interpretation. If a quorum is lacking, the CGI can appoint ad hoc judges. So if there is less number of judges, he can appoint ad hoc judges using High Court judges requiring the President's prior consent and consultation with respective of High Court Chief Justice. So CGI can appoint ad hoc judges. So he can bring High Court judges to Supreme Court on after the President's prior consent and consultation with High Court Chief Justice. Okay. Two more questions. Who appoints the acting Chief Justice of a High Court? Who appoints the acting Chief Justice? Now, don't get confused when this word comes in. If the Chief Justice is there, who is that? President. So, acting Chief Justice also President. Under Article 223, the President explicitly holds the power to appoint any acting Chief Justice. Don't get confused when the acting word is there. A person must have been an advocate of a high court for at least dash years to be appointed as a judge of Supreme Court. Of how many years? Minimum 10 years. Correct? So base qualification is either they have either a 5-year tenure as an high court judge or 10-year tenure as high court advocate. Correct? Regular appointments follow the collegium system, a procedural framework evolved through the three judges case. It explicitly not mentioned anywhere in the constitution. So it is an procedure convention which came out of the three judges case. It is not mentioned in the constitution. So just Supreme Court versus High Court diagnostic table, I have brought it for you. A quick comparison. While the Supreme Court is the apex, correct body, the Constitution carefully balances and distinguishes judicial power. Reviewing this final matrix, correct? Retirement age 65, Supreme Court, High Court 62. Writ Article 32, Supreme Court, High Court 226. Writ scope, Supreme Court, fundamental rights only, High Court, it is broader. Resignation of both the judges to be in to the President of India, and both the institutions, High Court and Supreme Court, have the power of court of record and contempt of court. Correct? So these were some very important parts which we learned about the judiciary. Do put your comments. Do stay tuned for further videos on such topics. Thank you, everyone. We'll meet you soon. See you.